Friends, I welcome you all to Clat lecture series, lecture 1 of the practice series. These classes are sponsored by Sri Jendra Rank Zone. I am your mentor Shekhar Gehlot. To give you a brief description of what these classes are going to be. In these classes, we are not going to discuss in detail about the subjects we have covered so far. Okay. So these are first of all these are only for CLAT aspirants, okay, not for CA foundational aspirants. These are exclusively designed for CLAT aspirants, and in these classes we are going to strike on the key MCQs which are being asked in the CLAT paper. So CLAT format comprises of around 200 questions, and all of them are MCQs. Okay, so MCQ is a multiple choice question in which a question is going to be asked to you, and then four or three options are going to be given to you, and you have to select one which is most appropriate question. Okay, so in this series, we are not going to discuss subject wise. We are not going to discuss that. Let us do the MCQs for constitution first, then law of contract first, then law of torts, and then crimes and family law. Not, we are not going to do it like this. We'll focus on assortment of the MCQs. The MCQs are going to be mixed MCQs from all the subjects. Okay, so as to keep you abreast with the uh, subject and the latest MCQs as well. Okay, so that it does not become a stereotypical thing and it remains entertaining, intriguing, and full of knowledge as well. So let us begin our class with the question number one. Okay, so let us read the question number one. The railway authorities allowed a train to be overcrowded. In consequence, a legitimate passenger, now a legitimate passenger is one who is having a ticket. Overcrowded means a lot of people have got into train without taking tickets. Mr. X got his pocket picked. Choose the appropriate answer. Mr. X can sue the railway authorities for the loss suffered. Mr. X can sue because he had given his consent to travel in overcrowded train. Sorry, Mr. X cannot sue. Mr. X cannot sue the railway authorities because there was no infringement of the legal rights, and mere fact that the loss was caused does not give rise to the cause of action. None of the above. Now, in this case, we'll discuss. This case hinges upon the theory we discussed, damage without injury. Okay, that means there has to be legal damage. Injury may or may not happen to you. There has to be infringement of legal rights, then only you can seek compensation. Sue means filing a case in the court for claiming compensation. Compensation for what? Compensation for pocket being picked. Okay, so in this case, Mr. X wants to file a case against the railways as his pocket has been picked because of the overcrowding of the train. But what is his legitimate right here? When he took the ticket, his legitimate right was to travel in the train. So he has got to travel in the train, but due to overcrowding, somebody has picked the pocket. Now, railway is not responsible for these antisocial elements. Plus, railway has put hoardings all across the railways and railway platforms that be aware of pickpockets. So, in this case, because there is no infringement of legal right, okay, there is no infringement of legal right. He took a ticket, and his legal right was that he should be allowed to travel. Now, he has been allowed to travel, but his pocket has been picked. That is not part of the ticketing. Okay, that is not part of the ticketing. So he has no grievance here. Yes, if he wanted to file a case that train was overcrowded and my comfort was distorted and I was assured a comfort. Now in this case he can definitely claim some compensation, but not for picking of pocket, because that is a purely law and order issue, antisocial issue. Railway cannot take responsibility for such acts. So the appropriate answer in this case is going to be C. Answer is C. Next is a principle. Okay, now in this case, in these kind of questions, a principle is given to you and we have to follow the principle. We have to apply the principle on given facts. Facts will be given just below the principle, and then we have to solve the MCQ. Now, what is the principle? A master is liable for the acts committed by his servant in the course of employment. This is just like we discussed in the case of vicarious liability. So, a master is liable for the acts committed by a servant in the course of employment. Facts. Sanjay is a driver working in the Brook Bond and Company. One day, the manager asked him to drop a customer at the airport and get back at earliest. On his way back from the airport, he happened to see his fiancée Ruhina waiting for a bus to go home. He offered to drop her at home, which happened to be close to his office. She got into the car, and soon thereafter, the car somersaulted due to the negligence to Sanjay. Ruhina was thrown out of the car, suffered multiple injuries. She seeks compensation from Brook Bond and Company. Now, what has happened in this car case is Brook Bond Company sent his driver to airport. Now, when he's coming back from airport, he saw his fiancée to be wife waiting for a bus. So he thought that why not I give you a lift and drop you to the house which is just near to the office. Okay, and they met an accident. Now, in this case, we are discussing master servant liability. Now, whether Brookbone and Company is liable for this accident caused by their servant Sanjay or not, let us see the options. Brookbone and Company shall be liable because Sanjay was in the course of employment at the time of accident. Brookbone and Company shall not be liable. Sanjay was not in the course of employment when he took Ruhina inside the car. Ruhina got in the car at her own risk and therefore she cannot sue anybody. None of the above. Now, in this case, we have to see whether he was employee, he was in the course of employment or not. Okay, if the Sanjay while accident happened was in the course of employment, then definitely because the master is Brookbone and Company, they are liable. If he was Sanjay was not in the course of employment, Brookbone and Company will not be liable. Now, let us see in this case what has happened. He had to go to the airport. He went to the airport. Just at the airport, he saw Ruhina, and then he took Ruhina in the car and drove to which location? He drove to the location of his office only. So now, what was the cause of employment for Sanjay in this case? His case was from office to airport, then from airport to back to office. Now, Ruhina's house is just near the office, so definitely he has not changed his way. So he was coming straight to the office, and meanwhile the car met an accident. That means when he was traveling to the route of office only and for the purpose of office only, he had gone to the airport for office and definitely he had to return to the office. So meanwhile in the way he suffered some accident. Rohina may or may not be traveling with him, but whatever happens within the course of employment, master would be liable. Now in this case the appropriate answer would be A. Answer would be A. Now, some of you may be thinking that taking Rohina was giving lift to Rohina is not part of his employment. Now, agreed that it is not part of his employment, but we'll not see it in such a manner. The pure nature has to be seen. Whether by giving Rohina a lift, was he required to take some other route than the route which he would have taken to his office? No, in this case, he is traveling straight towards the office. Okay, so in this case, he is covered in the course of employment. He is in the course of employment. His course of employment here was to come back from airport to office. Okay, plus there are no such instructions that he cannot give a lift to someone. So when there are no such instructions, nothing mentioned on the car, he has given lift to someone, and while going back to the office only, house happens to be near the office, while going back to the office only, if some accident happens, definitely the person is in the course of employment and the master will be liable. Nuisance as a tort, civil wrong, means an unlawful interference with a person's use of enjoyment of land or some right over or in connection with it. Okay, now the principle is that nuisance is a wrong which means unlawful interference with a person's use of enjoyment of land or some right over the land or some right in connection with land. Now look at the facts. During the scarcity of onions, long queues were made outside the defendant's shop, who, having a license to sell fruits and vegetables, used to sell only 1 kg of onion per ration cart. The queues extended on the highway and also caused obstruction to the neighboring shops. The neighboring shopkeepers brought an action for the nuisance against the defendant. Now, the neighboring shop, they have a right to have a free passage to their shop. Okay, but now there are people standing outside their shop and other people, other visitors cannot get access to their shop. Okay, and they are also finding difficulty in parking their vehicles and getting in and out of their shops, and the re- queue is spanning over kilometers. Okay, so it is obstructing the traffic at the highway as well. Now these shop owners, because they are now finally affected from the this queue, this nuisance, they go to the court to seek compensation from the vegetable seller. Okay, now let us see the options. The defendant is liable for nuisance. The defendant was not liable for nuisance. The defendant was liable under the principle of strict liability. The plaintiff should be decreed. The plaintiff should be decreed in his favor. Okay, that means the plaintiff should succeed. Okay, now one option say the defendant is liable for nuisance. Now in this case we have to see whether he has committed some nuisance or not. Now look at the facts of the case. Fact says during the scarcity of onions, that means country is going through a shortage of onions, and now he's supposed to sell only 1 kg per ration card. So definitely everybody wants onion and people have queued up. So in such kind of scenario, definitely people queue up and you have to manage the people in queues only. So what he is doing, it is not a kind of a permanent situation. It is a very temporary situation caused due to the scarcity of onions, and he is following all the rules of the government. So when you are following all the rules of the government, and sometimes there is extraordinary situation, okay, which is not a regular situation. Regularly there are not so queues in front of his shop. If this has been a regular feature, definitely it was a nuisance. But this is not a regular feature. It is an occasional feature and an emergency contingent feature. So in such a situation, we cannot hold someone who's lawful in doing his duty to be liable for nuisance. So the correct answer in this case is going to be point B, that he is not liable for nuisance. I hope you are getting the logic as well. Next is principle. Everybody is under a legal obligation to take reasonable care to avoid and act or omission which he can take reasonable care to avoid and act or omission which he can foresee would injure his neighbor. It should be an. Now, everybody is under a legal obligation to take reasonable care to avoid an act or omission which he can reasonably care to avoid, and an act and omission which he can foresee would injure his neighbor. The neighbor for this purpose is any person whom he should have in his mind as likely to be affected by this act. So now the principle says that anyone who is acting or doing something wrong should be aware about the consequences which is going to happen on the foreseeable expected consequences which are going to happen to the nearby person. Okay, so if I'm driving rashly, I should be aware that it might lead to an accident to my neighbor. My neighbor here is theoretically, that means anyone who comes in contact with me becomes my neighbor. Okay, so this is the case. Now let us read the fact. Krishnan, while driving a car at high speed in a crowded road, knocked down a cyclist. Okay, Krishnan is driving rashly in a crowded road and he knocked down a cyclist. The cyclist died on the spot with a lot of blood spilling around. Lakshmi, a pregnant woman passing by, suffered from a nervous shock leading to abortion. Now, Lakshmi is a pregnant woman who's passing by. She saw this dead person and a lot of blood around. She suffered a nervous shock. She could not take it, and this led to her abortion. Lakshmi filed a suit against Krishnan claiming damages. Okay, that because of the act of the Krishnan, it led to my abortion, plus I suffered a nervous shock, and then I am going through mental trauma and so on. Then Krishnan should compensate me. Now choose the right answer. The options are: Krishnan will be liable because he owed a duty of reasonable care to everybody on the road, including Lakshmi. This is yes, he definitely owes a reasonable care, duty of reasonable care. Okay. Krishnan will not be liable because he could not have foreseen Lakshmi suffering from nervous shock as a result of his act. This is also this may be possible. Krishna will not be liable to Lakshmi because he failed to drive carefully. Sorry, will be liable to Lakshmi because he failed to drive carefully. Yes, definitely this may also be possible. None of the above. No, this cannot be the option. Now let us see how Lakshmi has suffered harm. Has Lakshmi suffered harm because she was hit by the Krishna directly? No, she was not hit by the Krishna as per the fact. So this option goes Away, Krishna will be held liable to Lakshmi because he failed to drive carefully. His driving has nothing to do with the Lakshmi or injuries of Lakshmi. So this option is not going to be there. Now let us see all these two principles. He owed a reasonable care to everybody. Definitely he owed a reasonable care to everybody, including Lakshmi. But has he failed in his duty towards Lakshmi? No, he has not failed in his duty towards Lakshmi because his car has nothing to do with the Lakshmi. Okay, so now his duty, reasonable care duty, as far as Lakshmi is concerned, is satisfied. So this cannot be an answer. But let us see, Krishnan will not be liable because he could not have foreseen Lakshmi suffering from nervous shock as a result of his act. Now let us go back to the principle. Principle says act or omission which he can foresee would injure his neighbor, which he can foresee. So when someone is driving rashlessly, we can expect him to foresee that somebody may be hit. The death of the cyclist definitely is a foreseeable injury, but expecting that if I hit someone, blood will come out, and some pregnant lady would be nearby, and then she'll suffer a mental shock, and then she'll lead to abortion, and this and that. This is too much of high expectation from a person of a reasonable man, okay, a reasonable mind. So definitely anyone cannot expect these many consequences of particular act. Okay, so this was not a foreseeable act. Whatever happened to Lakshmi is a sorry state, but Krishnan cannot be held liable for the injury towards the Lakshmi because that is not the direct consequences or foreseeable consequences of his act. Okay, you cannot expect that by driving rashly, this would happen. Okay, this has happened. That's a travesty, but you definitely not expect this to happen. So our answer is going to be option B in this case. Nobody shall unlawfully interfere with a person's use or enjoyment of land or some right over or in connection with it. The use or enjoyment envisaged herein should be normal and reasonable, taking into account surrounding situations. Now, previous question we had only till this much the principle. Now they have extended the principle. The use or enjoyment envisaged herein should be normal and reasonable, taking into account surrounding situations. Now we have to take into account the surrounding situations as well. Let us see what is happening here. Jeevan and Pawan were neighbors in residential locality. Pawan started a typing class in a part of his house and his typing sound disturbed Jeevan, who could not put up with the so typing sound is like this kind of sound. It keeps on coming up. Okay, but when I'm making this sound is just near to my microphone, so it may be really disturbing to you people. But typing
It's
sound
7
is
o'clock.
not as disturbing as I may have sounded. Okay, so Pawan started a typing class in part of his house, and his typing sound disturbed Jeevan, who could not put up with the kind of continuous noise. He filed a suit against Pawan. Okay, so he is saying that I'm not able to enjoy my residential accommodation because Pawan has started a typing classes, and this sound is coming to me, and it is disturbing me. It's causing a nuisance to me. Now let us see the options. Pawan is liable because he should not have started typing class in his house. 1. Pawan is liable because as his neighbor he should have realized Jeevan's delicate nature. Pawan is liable because typing sound didn't create noise, though very marginal. Pawan is not liable because typing sound did not disturb anyone else other than Jeevan. Now, in this case, what we have to see the facts of the case. Facts of the case is that he has started a typing class, and typing class do make a sound, but the sound made by the typing class is a marginally less sound. Plus, he is doing it in his own house, okay, and within the four walls. So definitely, sound is going to be more curtailed as well. Okay, so sound is not as audible as if it would have happened in the open air. So definitely to Jeevan only a marginal sound of typing is reaching there. Okay, so now Pawan here has a right to livelihood, so he is exercising his right to livelihood. Jeevan has a right to reasonably enjoy his situations. Reasonably enjoy. He cannot expect it to be ultimately quiet and peace as per his own liking. So in this case, this is a case which we call in the law a case of a sensitive person, a case of a very sensitive person. So law takes in the situation of only a reasonable person, not a sensitive person. So if Pawan is extra sensitive and typing sound, which is not very much high, usually it is very marginally sound and can easily be avoided or ignored So if he is getting disturbed by that sound, then in this case, this is a case of an extra sensitive person, plaintiff, and then law cannot help such a person. So in this case, the option is going to be, because Pawan will not be held liable, so there is only one option which says not liable. So we'll go with the answer is D. We have to see into the facts and circumstances as well, okay, because this question principle says the user enjoyment and envisaged herein should be normal and reasonable, taking into account surrounding situation. So this is a normal use. Typing class is a normal use. It is not that he's giving racing classes there, okay, or music classes. It's a normal use of the land, and reasonably he's doing it inside his house. But still, if some noise is going outside as it usually would go, then it is always a very marginal, not even marginal, but very marginal noise. So in this case, we cannot help Jivan. That is, Jivan is extra sensitive. He has to himself cater for him. Principle: any direct physical interference with the goods in somebody's possession without lawful justification is called trespass to goods. Okay. Any direct physical interference with goods in somebody's possession without lawful justification is called trespass to the goods. A purchased a car from a person who had no title to it, okay, and had sent it to a garage for repair. X, believing wrongly that the car was his, removed it from the garage. Okay, that the car was his, removed from the garage. Now, in these issues, let us see what are the issues. X can be held liable, held responsible for trespass to the goods. X cannot be held responsible for trespass to goods as he was under a wrong belief. X has not committed any wrong. None of the above. Okay, none of the above. So now, in this case, answer is going to be B, because definitely he was under a wrong belief when he did so. So wrong belief is a justification. When you are doing something in a wrong belief, okay, when you have a bona fide belief but your belief may ultimately turn out to be wrong, then we call it a mistake of fact, and mistake of fact is may be excused in the law. Okay, but had this portion been removed, if this portion was removed from this question, if this question was like this, okay, any direct physical interference with the goods in somebody's possession is called trespass to goods. If this kind of question was asked, okay, we have to stick ourselves to the principle. We do not have to go into the situation. Okay, literally, we have to keep our emotions away and we have to stick to the principle. Now the principle has changed. Now principle does not talk about lawful justification. It says any direct physical interference with the goods in somebody's possession is called trespass to the goods. In this case, definitely answer A would have been appropriate. X can be held liable or responsible for trespass to goods, okay, because principle does not talk about this. We are subject to the principle. We are circumscribed by the principle. We have to just apply the principle to the facts without assuming any knowledge on our own part, okay. Principle: vicarious liability is the liability of master or principal for the tort committed by his servant or agent, provided the tort is committed in the course of employment. The master or principal is not liable for private wrongs of the servant or agent. Okay, so if the tort is committed in the course of employment, master or principal shall be liable. But if the torts are committed in the private capacity or private wrongs of the agent, then master or the principal shall not be liable. Now let us see the facts of this case. X hands over some cash money at his house to Y. Okay, who is X's neighbor? Now Y is X's neighbor. X gives some money to Y and is also cashier. Y is also a cashier in a bank to be deposited in A's account in the bank. Okay, now Y is a neighbor of X, but Y is also a cashier in a bank. So now X wants to deposit some money in A's account. So for that he is required to go to the bank. But what he did, he gave the money to Y because Y is his neighbor and asked him to deposit it in the A's account because he has to go to the bank because he is a cashier. Instead of depositing the money, Y misappropriates it. Now Y has embezzled the funds rather than depositing it. Now choose the following legal positions. A. The bank would not be liable because Y did not do any wrong in the course of employment. Okay. Now Y is the servant of the bank and bank is the master. The bank would not be liable because Y did not do any wrong in the course of employment. The bank would be vicariously liable because Y was the employee of the bank. The bank would not be liable because Y did not do any wrong. The bank would be liable because Y acted as a bank's agent. Okay. Now, in this case, if we see the facts, X hands over some cash money at his house to Y, who is X's neighbor. So now why X is handing over the money to Y is because they both are neighbors and they both know each other. There exists a private relationship between these two people. And owing to that private relationship, he has given the money to Y. X has not given the money to Y because he is the agent of the bank or he is the cashier of the bank. He has given the money for first relation he has with the Y for giving the money is because they both are friends or neighbors, they both are acquaintance, they both know each other. Cashier thing comes first. So now whatever dealing they are having, they are doing in the private capacity. So when they are dealing in the private capacity, whatever Y does, it becomes Y's private wrong. Okay, when Y's private wrong towards X is his private wrong, then the master or principal is not liable for the private wrongs of the servant or the agent. So the appropriate response in this kind of situation is going to be the bank would not be liable because Y did not do any wrong in the course of employment, because when he is dealing with his neighbor, he is not dealing as a cashier, he is dealing as a friend. So when a friend is doing anything wrong with another friend, bank or the master or the principal has nothing to do with that. Principle: a person has no legal remedy for an injury caused by an act to which he has consented. That is, like we discussed, voluntary non-fit injuria. That is the situation here. Or a cricket enthusiast purchases a ticket to watch a T20 match organized by the Indian Premier League. During the match, a ball struck for six, hits R on his body and injures him. He sues IPL for the compensation for the medical expenses. Okay, now he goes to watch a match in the stadium. A ball hits him, and now he sues IPL for compensation because he has received some medical expenses. Now, let us find the correct answer. R should be compensated as he purchased the ticket to get entertainment and not get injured. R would fail in his action as he voluntarily exposed himself to the risk. IPL would be liable as it did not ensure that the spectators were protected from the risk of such injuries. None of the above. Now let us see what the principle says. A person has no legal remedy for an injury caused by an act to which he has consented. Now when he goes to the watch an IPL match, it is assumed that somehow sixes may be shot in the match and the six definitely lands in the public, and public if not aware may get sometimes some injuries as well, but these injuries are not intentional injuries and these are accidental injuries which comes clubbed with watching such matches. So in this such case we can expect a person to be reasonably aware that some ball may hit him. He is reasonably aware that some ball may hit him. The stadium is an open stadium, but he still goes. That means he has consented to the act, he has consented to such injury. Then in this case, when he has consented, he has no legal remedy. So our answer in this question is going to be option B. R would fail in his action as he voluntarily exposed himself to that risk. Okay. Had it been the case that some batsman started beating him or some staff beated him badly, then we could not have then he could have definitely sued the IPL Foundation, and IPL Foundation will have to pay him back. But this is the risk associated with the watching of the match, and he has consented to it. So in this case, he cannot claim any injury. Why? Because we are bound by the principle. Principle. Damage without violation of legal rights is not actionable in a court of law. If the interference with the rights of another person is not unlawful or unauthorized but a necessary consequence of the exercise of defendant's own lawful rights, no action would lie. Okay, simply they are trying to say if I am just exercising my own legal rights, and by my exercise of my legal rights, I am causing no injury to someone else. I am not violating somebody else's legal right, but I am enjoying my own legal right, and some damage is occurring to someone else, then I am not responsible for it. Okay, now let's see the fact. There was an established school ES in a particular locality. Subsequently, a new school NS was set up in the same locality, which charged lower fees, on account of which people started patronizing the new school. Because the new school is having less fees, definitely people start going to that school. Because of the competition, ES had to reduce its fees. Now ES has to reduce its fees, otherwise students will go away, swoop to the new school. Okay, ES filed a case against NS saying that NS had caused it financial loss and thus claimed compensation. Which of the following derivations is correct? Since no legal right of ES has been violated, therefore, as such, no compensation could be granted. Since damage is caused to ES, therefore, it should be awarded compensation. ES should be awarded compensation as opening of school in competition is not good. No compensation could be granted as reduction in fees is good for public. Now, in this case, if we apply the principle to these facts, then what the school has done, school has NS, new school has exercised his own right, its own right of setting up a school, and it has decided to charge less fees. That is, they are doing nothing wrong. They are doing nothing wrong, but they are suffering damage. Why? Because increased competition is there. Due to competition, they are suffering some damage, but there is no violation of legal right. Okay, so now the principle in application here is which we discussed: injury sine damnum sine injuria. Okay, damage without injury. In earlier question, in earlier aspect, there was okay, there was injuria sine damnum. Okay, injury without damage. Now here it is damage without injury. Okay, so what is important in the law is injury, not the damage. There has to be violation of legal right. Okay, but there is no violation of legal right. So whatever damage they have suffered, they have to suffer. Okay, so in this case, the correct option is since no legal right of ES has been violated, therefore no such compensation could be granted. Okay, because no injury has happened. Just a second, please. 10. Principle: whenever there is an invasion of legal right, the person in whom the right is vested is entitled to bring an action though he has suffered no actual loss or harm and may recover damages. Now, in this is a case of injuria sine damnum, like we discussed. Injuria sine damnum in the law of tort we discussed, which means injury without damage. Okay, injury without damage means violation of legal right is there, though physical damage or otherwise damage, monetary damage may or may not be there, but violation of right is there. So now let us apply this injuria sine damnum to the facts. A was a qualified voter for the Lok Sabha election. Okay. However, a returning officer wrongfully refused to take A's vote. In spite of such wrongful refusal, the candidate for whom A wanted to vote won the election, but A brought an action. Now, what has happened in this case is A wanted to vote for a candidate. Okay. Despite him being an eligible voter, he was stopped from doing so. Okay, he was stopped from casting his vote. But however, ultimately, the candidate he wanted to vote for won the contest. So he has suffered no damage. But he was stopped from casting his vote, which is his legal right. Now let us apply this principle and see the right answer. Since no legal right of A had been violated, therefore, as such, no compensation could be granted. But this cannot be the case. Why? Because his legal right to vote has been violated. Since legal right of A had been violated, therefore compensation should be granted. This appears to be right. Let us see the other question, other sin option. No compensation could be granted as A had suffered no loss as his candidate won the election. Now that is the principle. Damage may or may not be the injury if there it is actionable. Since no fundamental right of A had been violated, therefore no such compensation could be granted. Now we are not talking about fundamental right. Injury is violation of legal right, may or may not be a fundamental right. So in this case, the most appropriate answer is going to be option B. Since legal right of A had been violated, therefore compensation should be granted. Answer is B. Principle: in a civil action for defamation, truth of the defamatory matter is an absolute defense. Okay, truth is an absolute defense. However, the burden of proving truth is on the defendant. Defendant means against whom a case has been filed or a person who has defamed someone. Okay, defendant, someone who has caused the defamation. Okay, that is why someone has gone to the court, and when someone goes to the court, he'll go against this person who has done some defamation, and this person becomes defendant, and he is liable if he does not successfully discharges this burden. Which burden? Burden of proving that whatever he is speaking is truth. Okay. D, who was the editor of a local weekly, published a series of articles mentioning that P, who was a government servant, issued false certificates, accepted bribe, adopted corrupt and illegal means to mint money, and was a mischief monger. P brought a civil action against D, who could not prove the facts published by him. Now the P is a public servant and D is an editor of a local weekly. So his newspaper is read by locality people. So definitely in this locality, if they are reading about P is a public officer. If they are reading that public officer is bribed, his reputation is going to be damaged. Now P brought a case against D, but D could not prove the facts published by him. D could not prove how he comes to the conclusion that P is a corrupt man. Now let us see what will happen in this case. D would be liable since he could not prove the facts published by him. Appears correct. D would not be liable as such an action could curtail the right of expression of freedom of speech and press. Okay, now they are trying to claim that press has a freedom of expression and speech. Now whatever is he saying, he has a freedom to say. No, but freedom of speech and expression is not an absolute right. It has some restrictions to it as well. You cannot injure someone's reputation in the garb of using your right. So this option goes out of the window. D would not be liable as media could publish anything. No, media cannot publish anything. This option is also not correct. None of the above cannot be a good option. So ultimately, the answer is option A. D would be liable since he could not prove the facts published by him and he has defamed someone, so he is going to be guilty. See, one more thing I would like to make clear to all you students that Clat does not give you this much time which we are investing in each question. You will have to practice all these questions and many more questions like this to be very ready to appear in the Clat. Okay, usual time allotted to you to perform is find an answer to a question is 1 minute, and that is a very less time. Okay, but we are doing it in a detailed manner so as to bring home, so as to teach you the basic of understanding the question and how we have to find an answer. Okay, but usually it is a very speedy exercise. Okay, so you do not have to do the analysis in this manner in which I am doing it to explain to you. You have to understand it, and then you have to go into the exam and you have to do it all very quickly. You are not allowed to take this much time in the exam, okay, ultimately, because it's a time bound exam. Next principle is a gift comprising both existing and future property is void as to the latter. Okay, a gift comprising both existing and future property is void as to the latter. X has a house which is owned by him. He contracted to purchase a plot of land adjacent to the said house, but the sale in his favor is yet to be completed. He makes a gift of both the properties to Y. Now he has made the gift of properties to the Y. Let us see what is the case here. Gift of both the properties is valid. Gift of both the properties is void. Gift of house is void, but gift of plot is valid. Gift of house is valid, but gift of plot of land is void. Now let us apply the principle here. A gift comprising both existing and future property. Now here existing property is the house owned by him. Future property which is going to purchase is plot of land, but he has not yet purchased it, so it becomes a future property. Future property is void as to the latter. Latter means later. Latter means later part. That is future property. That means gift of the future property will be void. Okay, but existing property will be valid. This is just they are playing with the English language, so you have to be very cautious about it. You have to read each the principle very carefully. Okay, on a summary reading, it may appear like they are saying that both existing and future will be void, and people may go with this option. Okay, but they are saying principle says existing and future property is void as to latter. When someone is making a gift which contains two kind of properties, existing and future, existing property will be valid, but future will be void as to the latter. Latter means future. So now the option is, because house is existing and plot of land is future, so he has made a combined gift. So in combined gift, latter is void, latter is gift of plot is void, so ultimate answer is going to be D. People have to read it. If you are going to read it in a hurry, you are ultimately going to this conclusion, which is going to be a wrong answer. Okay, so you have to be careful enough. Principle caveat emptor says let the buyer be aware, stands for the practical skill and judgment of the buyer in choice of goods for purchase. It is the business of buyer to judge for himself that what he buys has its use and worth for him. Once bought, and if the buy is not up to his expectations, then he alone is to be blamed and no one else. That means buyer has to be aware whatever he is purchasing, he should make good choice for himself. And if ultimately after purchasing he feels that I do not like this item or this item is not fulfilling my conditions, then he cannot blame anyone else, he has to blame himself alone. Okay, now let us apply this principle to the facts. For the purpose of making uniform for the employees, A bought dark colored cloth. Okay, A bought dark colored cloth. Just a second, please. A bought a dark blue colored cloth. Okay, he wants to do make uniform for the employees. cloth from B, but did not disclose to the seller the specific purpose of said purchase. But he did not tell the seller that I want to make uniform from this kind of cloth. When uniforms were prepared and used by the employees, the cloth was found unfit. Okay, for wearing as a uniform. However, the cloth was fit for a variety of other purposes, such as making caps, boots, and carrying carriage linen, etc. Applying the aforestated principle, which of the following derivations is correct as regards remedy available to A in the given situation? A. The buyer would succeed in getting some remedy from B. A. The buyer would not succeed in getting any remedy from B. B would not succeed in getting refund from A. A would succeed in getting different variety of cloth from B, but not the refund. But not the refund. Okay. Now let us apply the principle. Principle says buyer has to be aware if he is making judgment as per his own skill. Okay. Now he's using here his own skill. He did not inform the seller that why is he purchasing this color cloth. He just went and purchased the cloth. He sold the cloth. That's it. Cloth is suitable for some other purpose. He wanted it for some other purpose, but he did not disclose it to B. So he exercised his own judgment. Now ultimately, when he is suffering loss, then caveat emptor will come in and he will have to bear his own judgment. He cannot put the blame on B. So the option here is A would not succeed in getting any remedy from B. Okay, any remedy from B. This is the answer. He cannot claim any remedy because of his own judgment. Principle. The transferor of goods cannot pass a better title than what he himself possesses. Okay, the transfer of goods. Someone who is transferring goods, someone who is selling the goods cannot pass better title than what he himself possesses. Okay, he cannot pass a better title than his own title. Okay, so if I have borrowed some money, if I have borrowed some bike from my friend, and if I am selling that bike, I cannot transfer, I can only transfer the bike. I cannot transfer the ownership of the bike. Ownership will remain with my friend only, okay? But if my friend who is the owner, he transfer it, he'll transfer the bike as well as the ownership, okay? X sells a stolen bike to Y. Y buys it in a good faith. Now Y is buying it in a good faith. Okay, as regard to the title of bike, which of the following derivations are correct? The real owner cannot get the bike, cannot get back the bike from Y. Y will get no title as transferor. X's title was defective. Y will get a good title as he is a bona fide buyer. He is a bona fide buyer because it says he has bought it in the good faith. Y will get good title as he has not committed any wrong. Now, if we apply the principle says transferor cannot pass a better title than he himself has. So X has a stolen bike. So if he'll sell the bike to Y, Y may be buying it in the good faith or not, but definitely Y is buying a stolen bike. He is not buying a owned bike. He is buying a stolen bike. So his title is also of a stolen bike. So in this case, Y will get no title as transfer was title was defective, and Y will have to return the bike to the original owner. So answer is B. Negligence is a breach of duty or a failure of one party to exercise the standard of care required by the law, resulting in damage to the party to whom the duty was owed. Okay, negligence is a breach of duty or failure of one party to exercise the standard of care required by the law, resulting in damage to party to whom the duty was owed. Okay, to someone a duty was owed, but that duty was not fulfilled, and the other person has suffered that damage because of that carelessness. A plaintiff can take civil action against the respondent if the respondent's negligence causes the plaintiff injury or loss to the property. Now, applying these principles, its principle simply says that if someone is negligent or careless in his conduct and he results into injury to someone else or damage to someone else, then he is liable to pay back for the damages caused by his negligent or careless acts. D went to a cafe and ordered and paid for a tin or can of a soft drink. Tin or can, that means we have Pepsi can or tin can, which is opaque in nature. Okay, we cannot see through it. Okay, so the tin was opaque and therefore the contents could not be seen from outside. She consumed some of the contents and then lifted the tin to pour the remainder of the content into a tumbler. Okay, she first consumed something, some part of it. Okay, then she found that there is something wrong. So, to identify what is wrong, she lifted the tin to pour the remainder of the container content into the tumbler. Tumbler is a see through tumbler. The remains of snail in a decomposed state dropped out of the tin into tumbler. It was found out that the cold drink had a dead animal into it. Okay, and not only dead but decomposed as well, decayed. Okay, infested. D later complained of a stomach pain and a doctor diagnosed her as having gastroenteritis, gastroenteritis, whatever it is, and being in a state of severe shock. She sued the manufacturer of drink for negligence. Now she has filed a case for manufacturer for negligence. Okay, because manufacturer had a duty of care that he should not give a decomposed snail in the cold drink to people. Okay, so now he has failed in his duty and she has suffered damage. Now she has filed a case against the manufacturer. Now let us see what is the question further. Applying the aforestated principle, which of the following derivations is correct as regards to liability of manufacturer in giving situation? Now, what option is correct here? The manufacturer is liable for negligence as it owed a duty to customers to take reasonable care to ensure that its products are safe for consumption. The manufacturer is not liable for negligence as there is no direct contact between D and the manufacturer. No duty is owned by manufacturer towards a particular customer. The manufacturer is not liable for negligence because it would otherwise be very difficult for the manufacturer to do business. Manufacturer could be made liable under criminal law but not for the tort of negligence. Now, squarely applying the principle, we can find our answer that manufacturer is liable. Okay, because he cannot sell items which are not fit for consumption. Okay, master is liable for the wrongful acts committed by his servant. Master is liable for wrongful acts committed by his servant, provided the acts are committed during the course of employment. However, the master is not liable if the wrongful act committed by his servant has no connection whatsoever with the servant's contract of employment. Okay, so master will not be liable if wrongful act committed by his servant has no connection with the with his employment. Okay, now let us see the facts. D is a driver employed by M, who is the owner of a company. During the lunchtime, D goes to a close by tea shop to have a cup of tea. There he picks up a fight with the tea shop owner, which resulted in some damage to his shop. D wants to sue M for claiming compensation for the damage caused by the fight. Now find out the correct answer. M will be liable because D is his servant. His servant is going and doing something wrong at the tea shop nearby the office. So M will be liable. Both M and D will be liable. D will also be liable because he is also a guilty party. M will not be liable because the wrongful act picking a fight was not committed in the course of employment. M will not be liable because this act was not done in the course of employment. Okay, or M will be liable albeit the wrongful act, though the wrongful act was not committed in the course of his employment. Okay, we cannot make a master unlimitedly liable for anything and everything which an employee would do inside the employment or outside the employment. Okay, master is liable only for things related to the employment. Here, going to the tea shop is not a part of his job, that is outside the job, and then picking a fight there is his private affair. So, whatever he is doing, servant is alone liable, and M is not liable in this case because picking a fight is not part of the servant's contract of employment. He is a driver, not a bouncer. Okay, so the correct answer is going to be C. 17. Principle: trespass to land means direct interference with the possession of land without lawful justification. Trespass could be committed either by a person himself entering the land or another person or doing same through some tangible object. Okay, trespass could be done either by entering himself or by sending someone else or by doing something with the objects. A throws some stones upon neighbor's premises. Applying the principle, find the correct answer. A has committed trespass. A has not committed trespass as he has not entered B's premises. A has committed nuisance, none of the above. Now, if we apply principle, principle says trespass could be committed either by a person himself entering the land of another person or doing the same thing through some tangible object. Tangible object means something which can be seen, which exists in physical form. So stones exist in physical form. So throwing stones at someone else's property is trespass by some tangible object. So answer is A has committed trespass. Definitely he has committed nuisance as well. Okay. Some people may find nuisance also as a correct answer. But here we are subject to the principle only. Principle is talking about trespass. Had the principle here been nuisance, this option would have been correct. But the principle talks only about trespass, so we have to limit ourselves to the trespass only. Though this is also correct answer, but correct answer as per the question is option A only. Nuisance is an unlawful interference with a person's use or enjoyment of land or some right over or in connection with it. If the interference is direct, the wrong is trespass, whereas if the interference is consequential, it amounts to nuisance. Okay, if direct interference is there, it will be trespass. If it is consequential, okay, happening due to some other act of yours, then it amounts to nuisance. You are playing music and the music is being heard in the other house. Okay, that is a consequential act. You are not playing the music in somebody else's house. You are not taking your instrument to your neighbor's house and playing it there. No, but you are playing it so loud in your own house that sound could be heard in the other house. That is called a consequential act. Okay, because these are the consequences of your act. Now let us apply this principle and see the facts. A plants a tree on his land. However, he allows the branches to project over the land of B. Now the branches has gone over to the land of B. A has committed trespass. A has committed nuisance. A has not committed nuisance. None of the above. Now if we apply the same question in this principle, then the appropriate answer would be A has committed trespass. A has committed trespass. But in this case, we are not discussing about trespass. We are talking about nuisance and we have to find out whether he has committed nuisance or not. So we'll stick to only two options which are talking about nuisance. Trespass option is out of the course. None of the above is out of the course because definitely some nuisance has happened. Now let us see those two options. A has committed nuisance. A has not committed nuisance. This cannot be the option because he has let the branches go to somebody else's land which is not allowed. So our answer ultimately will be answer B. So enough for today's class, but I hope that you have understood the questions. And the key part is not to understand the questions, but the key part is to understand the principle and then apply it to the facts. Okay, a lot of options may sometime in a question, sometime it may appear that two options are correct. That like A has committed nuisance, it may appear correct. A has committed trespass, it may also appear correct, but we have to stick ourselves to the situation and to the principle. Principle talks about trespass, we'll talk about trespass. Principle talks about nuisance, we'll talk about nuisance only. We do not have to implant our own knowledge. Okay, enough for today's class. We'll meet in the next class. Thank you.